It's been a little over 30 days into Chief Justice UU Lalit's tenure, and in many radical ways, the Supreme Court looks unrecognizable. With sweeping structural changes, CJI Lalit has shown us what a constitutional court looks like. Let's begin. A day before taking office, Justice Lalit announced that the SC will hear 25 Constitution Bench cases covering critical issues of law starting in September. Many of these cases have not seen the light of day for years, with the oldest case gathering dust for over 35 years. This ambitious list covers key cases on reservations, religious rights, restrictions on freedom of speech, privacy, data protection law, criminal matters, citizenship, and more. The formation of the 25 constitution benches is particularly notable, as constitution benches have become a rare sighting at the Supreme Court. The average number of constitution bench judgments per year has dropped from 134 in the 1960s to just 2 in 2021. They came to a complete standstill during former Chief Justice N.V. Ramana's tenure. More importantly, a permanent constitution bench, one that would hear cases all year round, has never been seen before. After years of dedicating time to hearing appeals and miscellaneous cases, it appears that the Supreme Court's role as a constitutional court is being reinstated. Delivering far beyond what one may expect in a month, CJI Lalit formed 6 5-judge constitution benches to hear these cases. By the end of September, 25 out of 29 sitting judges at the Supreme Court were on constitution benches. Already, out of these 25 cases, 1 has been decided and 3 are reserved for judgment. The consequence of 4 settled constitution benches is exceptional for the judiciary. Including cases with similar issues that are tagged to these cases, the court will effectively clear 79 cases from its docket. A closer look at the topic of these cases gives an even better picture of this impact. For example, the biggest case from this list was before the CJI himself. 5 judges were hearing the challenges to reservations for economically weaker section introduced by the 103rd Amendment. The judgment is expected to clarify the purpose of reservations and its intended beneficiaries, a much-needed clarification across many pending reservation cases in India. CJI Lalit's rush in forming constitution benches makes it clear that the Supreme Court's efficiency is not hindered merely because 5 judges are occupied in a case at a time. The Chief Justice's innovative listing system may have pushed the Supreme Court to its most productive times in recent years. Under CJI Lalit, the SC is making a marked departure from being just a court of appeals, stuck hearing endless cases, most of which don't even ultimately make it to final hearings. So let's say you've come to the Supreme Court with a case that raises crucial legal issues. Answers from the top court on these questions will have ripple effects across the country, making citizens' understanding of the law clearer. The court, recognizing that your case raises crucial questions, has admitted it. All that remains now is final arguments. Simple, right? Not really. In a pre-Lalit Supreme Court, your case would not be heard on Mondays and Fridays at all. The court reserves these days to hear cases at the admission stage, where the bench will decide if an issue is worth adjudicating in the first place. You may think that it's still not a cause for concern. You still have 3 remaining days in the week where you may get your hearing. But consider this. The court used to begin Tuesdays, Wednesdays, and Thursdays with admission hearings again. Mornings dedicated to miscellaneous hearings spilled over to the rest of the day and ended with a host of critical issues that never reached the bench. CJI Lalit fixed this schedule with a simple switch in the order. Now, on Tuesdays, Wednesdays, and Thursdays, all benches begin the day with final arguments in admitted cases and get to the miscellaneous cases later. The new system budgets the court's time smartly to prioritize clarifying questions of law. However, it does not ignore that miscellaneous cases actually make up a majority of the number of pending cases at the SC. The new system also incorporates constitution benches in the mix, ensuring that cases of varying complexity all get their due and are ultimately cleared from their pending docket. While constitution benches and new listings created a system to chip away at the behemoth pendency problem, a notice that was issued mid-September cleared 13,000 cases in one fell swoop. These were cases that had occupied the court shelves for over 8 years and seemed like the parties did not intend to prosecute any further. The Supreme Court's registry has the duty to assess if petitions filed at the Supreme Court contain all the basic components. So if a petition is satisfactory, it is sent to the judges to hear it. If not, the registry sends it back to the applicant, pointing out the defects in the petition. Typically, the applicant has about 28 days to return with a revised petition. Sometimes the court may even allow a 90-day extension. So in this September notice, the registrar claimed that little to no action was taken by the parties to cure defects in these 13,000 cases. The registry almost never heard from them again. Nothing literally survives now, the registrar passionately wrote while dismissing these cases. The fact that CJI Lalit inherited the court with over 70,000 pending cases puts this dent in sharp focus. Nearly 20% of the court's backlog is lifted with this move. On September 26th, the Supreme Court brought back another batch of forgotten cases ready for speedy clearance. A notice stated that 300 of the oldest cases in the Supreme Court would be scheduled for hearings in October. The oldest of these cases go all the way back to 1978. The caseload cleanup seems to be diving deep and may just be the first step in clearing 70 years worth of clutter. The changes brought about by CJI Lalit shows a sincere and meticulous approach to clearing the Supreme Court's mammoth backlog. This is a breath of fresh air after we saw a post-COVID court crumble under its caseload. The court's commitment to address tricky and contentious questions of law is also a welcome departure from the past CJI's approach of leaving such cases in the cold storage. CJI Lalit's tenure has but 3 working weeks left before his retirement on November 8th. He has evidently figured out how to work around his time constraints. It remains to be seen, however, if his structural changes will survive past his retirement. We hope you enjoyed our weekly update. For more, visit scobserver.in.